And oftentimes, Margie, you and I know this, we get family professionals involved with the family to understand the conflict, improve communication, to really help prepare a plan, not only for the parents, but also the lawyers involved, if you're doing it collaboratively, in terms of what options might work best for this family. So you're generating options, looking at goals and interests, completely different than what you're doing in court with emotion, where you're taking an adversarial position, usually saying something nasty about the other side and their lawyer. So I think it's a great idea, and I'm certainly all for it. Did you want to add into that, Cindy, before we move on?
No, I believe you guys covered everything.
Okay. Want to hammer a couple quick questions here. One is there a plan in place for family courts to have a starting point of 50-50? No, the Divorce Act and other legislation focuses on best interests of the child. 50-50 was sort of a maximum contact principle that was done away with the legislative changes. This is kind of an important question. In case of domestic violence and kids involved, how can I protect my kids and contest a motion from the other parent for parenting time and access? You need to set out what your concerns are. Would you agree, Margie, in terms of your material?
Yes.
And talk about the domestic violence, right? How that's.
Yeah, and I mean, it's kind of difficult to, you know, especially on interim motion, like a temporary motion, to provide that sort of evidence. When you're at trial, you have, you know, you can cross-examine people, you can have experts, but an interim motion is kind of like, it's based on affidavit evidence, and oftentimes they're conflicting, contradictory, right?
Yeah.
So the best way to do that, I find, is to and you know, some lawyers might disagree with me, but I find that it helps me in my cases, is to get as much evidence from other people about really bolstering why your plan is better, right? Try to steer away less. You have to go into what the domestic violence is, but really don't use the domestic violence situation to sort of paint the other party as bad parent, good parent. I find it helps when you try to tell the court, this is why my plan is better. And one of those reasons is because there is domestic violence, right?
And there could be other information already available, right? Through police reports, children's aids,
doctor's letters.
Right, recommendations from professionals, even what teachers or school officials are observing as well in terms of the children's behavior. So that goes a long way. The second part of that question was a really good one too. So the kids are saying, voicing a concern and don't want to be with that parent. We have a whole live event series just on the voice of the child and the age that the children's wishes should be looked at. So we'll refer that person to that resource. Final question I want to get to, somebody's concerned that the father who has status quo isn't going to do well in court with the mother. The plumbing doesn't matter. What the court's concerned about are parenting plans in the best interest of the children. So this idea of a 10-year years doctrine where children should be with their mother from 30 or 40 years ago, I don't think carries much weight. It's more who's got the best parenting plan. So there's bad things we need to talk about too.